Welcome back to Organize, the business law breakdown. I'm your host, Seth C. Oranburg, and today we're tackling a critical and sometimes surprising aspect of contract law: mistakes. Contracts are supposed to bind parties to their agreements, but what happens when one or both parties are fundamentally wrong about some key fact? Well, that's when mistakes break contracts. Imagine buying a painting at a garage sale, thinking it's just a pretty picture for $5, only to discover later it's a rare masterpiece worth millions of dollars. Can the seller come back and say, "Oops, I made a mistake. I want my painting back"? Or does the law hold them to the deal? Today, we're breaking down when mistakes allow contracts to be undone and when you're stuck with your bargain, even if it turns out differently than expected. In our last episode, we covered the statute of frauds and why certain contracts need to be in writing to be enforceable. Today, we shift our focus to the doctrine of mistake. We'll explore what constitutes a legal mistake in contracts, the difference between unilateral and mutual mistakes, and how the law addresses these issues. We'll dive into famous cases like Sherwood v. Walker, also known as the case of the barren cow, and Wood v. Boynton, where the sale of a mysterious stone turned out to be a diamond in the rough. We'll also talk about different rules for unilateral and mutual mistakes and why courts handle them differently. So, if you've ever wondered when an oops in a deal can get you out of a contract, stay tuned. We're about to unravel the rules surrounding mistakes in contracts. Now that we've set the stage, let's dive into the core concepts behind the doctrine of mistake in contract law. A mistake, as defined in the Restatement Second of Contracts, is a belief that is not in accord with the facts. In other words, both parties can genuinely believe they're making a deal based on some truth, but one or both may have an erroneous belief about a fundamental fact, leading to the legal dispute that falls under the doctrine of mistake. Let me just read it one more time. The definition is a belief that is not in accord with the facts. And one thing I'll point out at the front end is you need to have some truth available, as opposed to a subjective perspective for the mistake doctrine to kick in, because we have to have facts, not a prediction about the future and not an opinion about the world. If I feel happy today, that's unlikely to be a fact. It has rained 2 millibars today. That would be a fact. So let's break down two types of mistakes: unilateral mistakes and mutual mistakes. In a unilateral mistake, only one party is mistaken about the key fact. This could be something like misjudging the value of property or misinterpreting the legal rights associated with a contract. However, for the mistaken party to void the contract, to avoid the obligation, the mistake must significantly alter the transaction and not be due to the mistaken party's own negligence. One famous case that illustrates this is the Prince v. Starboard, where a cruise ship's jewelry store mistakenly quoted a price for a diamond that was just 1/20th of its real value. It turns out, by the way, that diamonds are priced according to their carat weight, so you have to multiply that price times the number of carats. And for a 20-carat stone, this was a pretty big mistake. On the other hand, in a mutual mistake, both parties are wrong about a key fact, often making the contract voidable. One of the most famous examples of this is the case of Sherwood v. Walker, where the sale of a supposedly barren cow fell apart when it was discovered the cow was fertile and worth much more than the agreed upon price. However, an interesting backstory to this case: although the case is trumpeted in all of the major treatises as the case of mutual mistake, one of my students did research and discovered that one of the parties probably knew the cow was fertile. But we'll use that case for its place in legal history, as we will. Its fictional value is worth more than the reality of the case in that case. But people are mistaken about the mistake case. So here's the key rule. Under the restatement, for a mutual mistake to void a contract, right, and a mistake is a belief that is not in accord with the facts, That mistake must go to the very heart of the agreement. It must be a basic assumption on which the contract was made, and must have a material effect on the agreed exchange of promises. So it can't just be any mistake about anything, like I thought you were going to sign the contract in a green pen and you used purple. Okay, not really what we're talking about here. I thought that I was buying an iPhone 13 and I got an iPhone 10. Well, that might be a big difference. This is why courts are more likely to void mutual mistake cases as well, because when two parties are both mistaken about something that is critical, that goes to show that was a basic assumption. The fact that both parties held it in their minds suggests that it was a basic assumption. It's also important to note that courts won't grant the defense of mistake if one party bears the risk of mistake. At least the party who bears the risk of mistake cannot avail themselves of the mistake defense. How does a party get the risk of mistake? Who would want that anyway? Well, contracts are about assigning risk to parties so that one person is responsible if certain things happen and another is responsible under another set of events. For example, if a buyer knowingly purchases a piece of property, quote, as is, they've assumed the risk if there are any mistakes about the property's condition, if there's any hidden defects. So if you buy a property as is, you should probably get it inspected or you're stuck with the leaky roof. Ultimately, the doctrine of mistake is designed to balance two key principles in contract law: fairness on the one hand and certainty on the other. Courts want to avoid enforcing contracts based on serious errors that undermine the agreement, but they also want to make sure that parties take responsibility for their own due diligence before entering into contracts. Now that we've laid out the key concepts, let's break down a couple of cases that highlight how these principles apply in the real world. We'll start with Wood v. Boynton, where a mysterious stone turns out to be far more valuable than either party could have predicted. The case of Wood v. Boynton is an 1885 case, and they didn't really distinguish at that time between mutual and unilateral mistakes, so it's just known as a mistake case, but it is a big mistake. This case involved a stone of unknown value that was sold for a mere dollar, and it turned out to be a literal diamond in the rough. The Eagle diamond, a famous diamond, worth significantly more, at least $500 in money at that time. The story starts with Ms. Wood, who brought an identified stone to Mr. Boynton's jewelry store. Both parties weren't aware of the stone's true nature. Wood thought it might be a topaz, because I guess it looked a little yellowy from the outside, but she wasn't certain. Boynton didn't have any idea. At the time, Wood needed some spending money, so she sold the stone to Boynton, a kind of pawnbroker, for $1. It turned out the stone was an uncut diamond, a diamond in the rough, worth $500 to $700. When Wood discovered its true value, she demanded the return of the stone, claiming the contract should be rescinded due to the mistake. But here's the key issue. Was there a mistake? What was the mistake in this case? Well, the court actually said there was no mistake. Let's unpack this puzzle. What does Miss Wood claim is the mistake? Well, she claims that she thought a stone was a topaz, and it turned out to be a diamond. So she had a belief that the stone was a topaz, which was not in accord with the facts that the stone was a diamond. But is that really what she believed? Or rather, did she believe she had a stone of uncertain value? It's a rough stone. She's not a gemologist. She didn't really know what she had. She actually had a correct belief. She didn't have a mistaken belief. She believed she had a stone of unknown value, and she had a stone of unknown value. Now, it turned out to be a high-value stone, but that was a prediction about the value of something in the future, not a belief about a fact, at least according to this court. Now, the court's analysis is 1885 style. It's a little thin and short, and we don't get the whole picture. But I think part of it, too, is the court's telling Ms. Wood that she bears the risk of mistake in this case. They wouldn't grant the defense to her anyway. So even if this were a mistake, she probably bears the risk because a party generally bears the risks of mistakes about value that affects them, unless the party is deceived. But we'll talk about misunderstanding, misrepresentation, fraud, duress, and undue influence in our next episode. But unless a party is deceived, then They're responsible for determining the value of the things they buy and sell. Wood took a risk. She took the risk that the stone be worth more than she thought. Boynton also took a risk. Boynton took a risk that the stone would be worth nothing. It turned out that Wood lost this gamble, but if everyone could rescind their contracts wherever they ended up making a bad prediction, we wouldn't have a lot of enforceability in contracts. So Wood v. Boynton teaches us that just because a deal turns out to be better or worse than expected, it can't mean a mistake has been made in the eyes of the law. But what happens when something isn't about value, but something more fundamental? Let's discuss a what if. What if you're at a yard sale and you find a nice looking lamp? The seller believes it's just an old lamp and sells it to you for $20, and you buy it. But after doing some research, you discover it's an antique Tiffany lamp worth thousands of dollars. Now the seller contacts you, demanding the lamp back, claiming they made a mistake. Can they undo the sale? No, they probably can't. Much like in Wood v. Boynton, the parties were aware that they were dealing with something of uncertain value. The seller knew they were selling a lamp and you bought a lamp, but there was no discussion around it being a Tiffany's lamp or an ordinary lamp. The fact that it turned out to be far more valuable than either of you thought does not amount to a legal mistake that would lead to rescission of the contract. The seller assumed the risk of the lamp's value, and the contract remains enforceable. And by the way, if you went home and plugged the lamp in and it didn't function at all, you also probably could not take it back, because this was likely a situation where you would have understood the sale was as is and did not include any warranties of merchantability. You can check out my future podcast on UCC warranties for more on that. Now let's turn the tables. What if the seller thought the lamp was a vintage Tiffany's lamp and was offering it at a high price? And you didn't know much about lamps, but thought it looked cool. You bought it and then later found out it was just a reproduction made recently in China, worth only a fraction of what the seller believed an original made in America 1940s vintage Tiffany's lamp would be worth. Can you demand a refund, claiming the contract was based on a mistake? Well, it may seem like we've just inverted the facts, but I've actually added a complication here. If the seller genuinely believed to be selling a valuable antique and communicated that belief to you, but it turned out to be a reproduction, you might have a case for rescission based on mutual mistake. And mutual mistake is easier to get a rescission for than unilateral mistake. Both of you shared the same incorrect belief around the nature of this object, and that shows the mistake goes to the very heart of the agreement. And if the seller communicates a false belief to you, the seller may have now made a false assertion, causing your false belief. I will discuss that in our next podcast on misrepresentation. Finally, let's consider one more what if. What if you were only mistaken and the seller knew it wasn't a real Tiffany lamp, but they never corrected your assumption? In other words, what if you told the seller, "I like your Tiffany lamp," and the seller said, Could you claim unilateral mistake and avoid the contract? Look, again, unilateral mistake, where just one party is mistaken, is much harder to prove. Courts are reluctant to let a party undo a deal just because he or she was mistaken, especially if the other party wasn't at fault, because we'd unwind a lot of contracts this way. And most parties are responsible for their own mistakes. However, if the seller actively misled you, or in certain cases was silent under a duty to speak, this could have been a misrepresentation, which we'll discuss in the next episode. So as we've seen, whether a mistake can undo a contract depends on several factors, including whether both parties were mistaken or just one, and whether the mistake went to the very heart of the deal or simply affected its value. Now that we've explored these what-if scenarios, let's move on to breaking down another case, Sherwood v. Walker, the famous case of the barren cow and the legal battle over rescinding their contract. Sherwood v. Walker is known as the case of the barren cow and is used as an illustration of mutual mistake, although a student of mine did some research and gave some compelling evidence that one of the parties actually knew the cow was fertile. But in any event, let's go with the story as it's been ensconced in the history of the legal canon, where both parties were mistaken about the fundamental fact of the cow, which, by the way, was named Rose II of Aberlour, which is also mistranscribed as Aberlour in the case. But Rose was apparently thought to be barren. And barren cows are worth less than fertile cows because fertile cows could do something barren cows can't do. And that's for another podcast. In this 1887 case, Mr. Sherwood agreed to buy a cow named Rose from Mr. Walker, again believing the cow was barren and of low value, about $80. 1887 money. Both parties shared the belief, according to the case. And the cow was sold for a price based on its transaction on its value as beef. All you could do was eat this cow. However, before the transaction was completed, it was discovered that the cow, Rose, was not barren, but fertile and with calf, and worth significantly more as a breeding cow, maybe $800, 10x more. Walker refused to deliver the cow, and he argued the contract should be rescinded due to the mutual mistake. Who should win this case? Well, the Michigan court sided with Walker, finding that the mistake about the cow's fertility went to the very heart of the contract and changed the nature of the transaction itself. Key issue wasn't simply the value of the cow, but the nature of the cow. And a barren cow, the court reasoned, is substantially different from a fertile one. Maybe even to the extent that a cow is different than a bull, or a chicken is different than an orange. I don't know. These are different things, according to this court, fundamentally different things, because you use them in 1887 farming for vastly different purposes, and you assign vastly different values to them. Since the assumption around the cow's fundamental nature was wrong, the court voided the contract. And moreover, since that was a mutual mistake, the court was more likely to grant it, since both parties were mistaken. Sherwood v. Walker shows us that mutual mistakes can allow contracts to be undone when the mistake goes to the very essence of the agreement. Both parties here believe they're conducting a barren cow transaction, and when it turned out that Rose was fertile, the basis of the deal collapsed. The court found that enforcing the contract would be unjust because the nature of the animal was fundamentally different from what the parties believed. So, whether it's a barren cow or a diamond in the rough, mistakes can have major consequences in contract law. Let's take a look at how the concept of mistake shows up in pop culture. One example is from the movie Trading Places, a 1983 comedy, where two wealthy brothers, Mortimer and Randolph Duke, made a bet on whether a street hustler, Billy Ray Valentine, could become a successful commodities broker. Meanwhile, they ruined the career of an executive, Louis Winthorpe, by manipulating a series of misunderstandings and mistaken assumptions about his behavior. The entire premise of the movie is built on errors in judgment and mistaken beliefs, leading to a chaotic and comedic unraveling of careers, fortunes, and relationships. In Trading Places, we see how misunderstandings and mistakes have serious consequences, just like in contract law. The Duke brothers manipulate the situation through their misrepresentations, and so the promises they made would probably be voidable. The movie shows what happens when mistakes, whether about a person's behavior or the value of a commodity, drive decisions that lead to unexpected outcomes. We also see the concept pop up in the TV show Friends. In one episode, Joey buys a large entertainment unit, thinking it's a great deal, but he fails to account for its enormous size, which barely fits in his apartment. While this is a much lighter take on mistakes, it reflects a common scenario. When someone makes a decision about an incorrect assumption about the suitability or validity or value of a purchase, they're usually stuck with it. Now look, a lot of companies offer return policies, but that's their policy. They don't have to take it back as a matter of law, just because you didn't measure the door before you bought the TV. Whether it's a high-stakes financial bet in Trading Places or a misguided purchase in Friends, pop culture often mirrors legal principles that mistakes can lead to unintended consequences. The same is true in contract law. Mistakes, whether mutual or unilateral, can reshape deals in ways no one expects. So let's wrap up today's episode with a key recap of takeaways. We started by exploring the concept of mistakes in contract law, focusing on the difference between unilateral and mutual mistake. In Would-Be Boynton, we saw how parties were unaware of the true value of a stone, but the contract held because the risk of uncertainty was shared. On the other hand, in Sherwood v. Walker, both parties believed the cow was barren, but when it turned out that they were wrong, the contract was voided because the mistake went to the very heart of the agreement. The key takeaway is not every mistake can undo a contract. In fact, it's kind of exceptional when it does. Courts only void a contract when the mistake is about something fundamental to the agreement, like the nature of the object being sold, and usually not its value. Mutual mistakes are more likely to be grounds for voidability of a contract, while unilateral mistakes are harder to win on because in general, a party bears the risk of its own mistake. Have you ever purchased or agreed to a deal only to find out that later things weren't as they seemed? I'd love to hear your stories or questions about mistakes in contracts. Share them with me and you might hear your experiences in future episodes. That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Oranburg, and I thank you for tuning in and contemplating the doctrine of mistakes with me today. I hope you found the episode informative and helpful. Remember, until next time, keep your agreement strong and your argument stronger.